According to the title of my presentation, I will talk about the recent judgments delivered by the Court of Justice of the European Union on consumer law matters. Before starting to analyze a few judgments that I've selected among those delivered by the Court in the last few months, I would like to briefly recall the role of the Court of Justice in ensuring consumer protection. As you all know, the creation of the single market has given consumer access to a wider range of goods and services and has increased competition between businesses. So the European Union has passed a significant amount of legislation. We have seen it yesterday, we will see it today again, aimed at protecting the consumer in different sectors. At the same time, EU has developed a system that enables national courts to protect the rights of consumers. The Court of Justice is at the top of this structure, which has involved a remarkable degree of cooperation, we will see how, between the court itself and the national courts. In what consists the work of the court? As you know, the court mainly deals with requests for a preliminary ruling. So when a national court is uncertain as to the interpretation or validity of an act adopted by the European Union, it stays the proceedings before it and refers the matter to the Court of Justice, which gives a ruling on the interpretation or the validity of the provisions in question. When the matter has been clarified by the court, then the national court is in a position to settle the dispute before it. But let's have a look to what is the purpose of this system, because we'll talk about it later. It's to avoid different interpretation and application of EU law among member states and to ensure that EU law is respected and correctly applied in those member states. Just to give you an idea on a statistic basis of what happened in 2019, 966 cases were brought before the Court of Justice. 644 of them were preliminary ruling proceedings. It represents so almost 70% of the work of the court, and over 10% of the court judgments were delivered in cases directly or indirectly connected to consumer law matters. Why the role of the Court of Justice is so important in protecting consumer rights? Because over the years, the court has delivered judgments in which, by interpreting EU law, it has granted to consumer ever more extensive rights. And we'll see how the court made this job. This slide shows you which are the main areas in which the court has delivered its judgments in the last few years. Of course, this is a non-exhaustive list because there are other sectors that in which the court has judged. The first sector concerns the unfair commercial practices. The court has developed an extensive body of case law on the subject and, among other, on combined offers made by vendor to consumer, aggressive practices by traders which give the consumer, for example, the false impression that he has won a prize, whereas he actually has to incur some costs in order to receive it, or calls to an after-sale telephone number which must not exceed, as the court stated, the cost of a standard call, otherwise they constitute an unfair commercial practice. The second sector concerns the unfair contract terms. As you all know, the Directive 93/13 provides that consumers are not bound by unfair terms in a contract concluded with the seller or a supplier. The court has ruled on numerous cases in this field and has clarified the scope of that directive. For example, the court has clarified that national courts are required to examine of their own motion whether a term contained in a contract may be unfair. The third sector concerns the food and drink. You know that the court has delivered many judgments in the field, especially concerning the product labeling, in which the court reiterated that consumers must be provided with correct and comprehensive information regarding the content and composition of products. Distance angling sector, we've been talking about that yesterday, especially concerning mail order sales. We have seen that in the digital age, mail order sales have become a common transaction in everyday life. The court has clarified on several occasions the rights of consumers, in particular when they buy goods online. For example, regarding the right of withdrawal of the consumer, the court has stated that the cost of delivering goods must not be charged to a consumer who exercises his right of withdrawal. The consumer may, however, be charged for the cost of returning the goods. In addition, a consumer who exercises his right of withdrawal is not required to compensate the seller for the use of the goods, unless, of course, he has used those goods in an unreasonable manner. The fifth sector concerns the defective goods. You know that the court had the occasion to clarify the rights of consumer where they claim that the product delivered to them is defective. The insurance contracts is also a sector in which the court has delivered a few judgments. And then, I won't be long on that, we will talk about that later. Later, we have the last two sectors, passengers' rights and processing of personal data. I'll talk to you about a few judgments on this sector. Due to the consistent amount of judgments delivered by the court this year, it would be impossible, of course, to discuss about all of them. That's why I decided to select some of the most relevant cases in three main areas. The first one concerns the unfair terms in consumer contracts. In many occasions, in particular in the last few years, the court had to precise the rights of consumers when they are involved in contracts containing unfair terms. The second area of judgments concerns the right of air passengers in the recent case law. This is an area in which the court is particularly asked to intervene in the last times. We'll see that many judgments have been delivered by the court during the last months, and probably, I suppose that many cases will be soon brought before the Court of Justice for disputes raised during the COVID-19 period. The third and last section concerns case law which is strictly connected to consumer protection. I'm referring to the processing of personal data. We'll discuss about two important cases brought before the Court of Justice, the Privacy International judgment delivered by the court last Tuesday, and an important pending case concerning Facebook after the Schrems II case, which has been judged in July 2020. We have another pending case concerning Facebook Highland, in which the hearing was held last Monday. Let's start with the unfair terms in consumer contracts. I will talk to you about this judgment delivered by the court last March in the case Gomez del Moral Gouache, in case 125 of 2018. The judgment was delivered by the Grand Chamber of the court, so it states how this judgment can be important in consumer rights. I choose this case for two reasons, because it shows, in my opinion, the high level of cooperation that the Court of Justice establishes with national courts, and at the same time, it also shows how deep can be the intervention of the Court of Justice to ensure consumer protection in situations where the court considers that the consumer is in a position of weakness vis-à-vis the supplier or the seller. Let's have a look to the facts of this case. In 2001, Mr. Gomez concluded a mortgage loan agreement with the banking institution for an amount of 130,000 euros. He wanted to buy a house. A clause of that agreement, entitled variable interest rate, contains a contractual term pursuant to which the interest rate to be paid by the consumer is to vary according to the index fixed by the Spanish bank. Mr. Gomez brought an action before a Spanish court seeking a declaration that that term is void because unfair. And why it was unfair? Because, as the referring court notes, the indexing of the variable interest rates applied to that contract is less favorable than the one calculated on the basis of the Euribor index. And it involves an additional costs for the consumer of around 18,000 euros per loan. In those circumstances, so the National Court decided to stay the proceedings and to refer to the Court of Justice a few questions on the interpretation of Directive 93/13 for a preliminary ruling. What the court said. First of all, answering to the first question of the referring court, the court analyzes if such a term falls into the scope of Directive 93/13. The court recalls that according to Article 1, Paragraph 2 of the directive, the contractual terms which reflect mandatory provisions are not to be subject to that directive. However, and even if the contractual term included in the agreement signed by Mr. Gomez is provided for by the Spanish legislation, the court observes that it falls within the scope of Directive 93/13 because the national legislation does not contain any obligation to provide for the application of one of the 6 official indices provided by the Bank of Spain. In other words, there is no binding application of a specific index. In the second place, the court looked at the powers of the national courts when verifying the transparency of a contractual term relating to the main subject matter of a contract. And especially in paragraph 43 of the judgment, the court points out that the system of protection introduced by Directive 93/13 is based on the idea that the consumers are in a position of weakness vis-à-vis sellers or suppliers, as regards both their bargaining power and their level of knowledge. So this leads the consumer, according to the court, to agree to terms drawn up in advance by sellers or suppliers without being able to influence the content of those terms. So in light of that position, in the light of that position of weakness, according to the court, the Directive 93/13 requires member states to provide for a mechanism ensuring that every contractual term that has not been individually negotiated with the consumer may be reviewed in order to assess whether or not it is unfair. And the court observes that according to Article 4, paragraph 2 of Directive 93/13, the courts of a member state are always required to verify that the contractual term relating to the main subject matter of a contract is plain and intelligible. According to the court, that requirement applies even if the member state concerned, in this case, Spain has failed to transpose that provision into its legal system. In the third place, the court finds that in order to comply with the transparency requirement for the purpose of the directive, a contractual term setting a variable interest rate in a mortgage loan agreement must enable an average consumer to be in a position to understand what's going on, to understand the specific functioning of the method used for calculating that rate, and thus evaluate the potentially significant economic consequences of such a term on his or her financial obligations. Finally, and in fourth place, with regard to the powers of the national court relating to a possible finding that the contractual term is unfair within the meaning of the directive, the court stated that the directive does not preclude the national court, where an unfair contractual term is null and void, from replacing that index with another index according to national law, insofar as the mortgage loan agreement in question is not capable of continuing in existence if the unfair term is removed, and the annulment of that agreement would expose the consumer to unfavorable consequences. This second case concerning unfair terms in consumer contracts concerns a situation where two consumers concluded credit agreements for the grant of personal loans with the Raiffeisen Bank and another bank. After those loans had been repaid in full, they brought an action before national courts in Romania to seek out that the number of terms included in these contracts were unfair. Raiffeisen Bank contested this action because considered that as the contract were performed in full, the two clients had no more the status of consumer, and so they were no longer entitled to bring proceedings before national courts to ask for a reimbursement of what they paid. The national court considered that full performance of the contract was not an obstacle to examining the unfair nature of its terms, and found that those terms were unfair. So it ordered to Raiffeisen Bank and the other bank to reimburse the clients. Of course, the banks appealed against this judgment, and in this context, the national courts asked to the Court of Justice whether the Directive 93/13 on unfair terms in consumer contracts continues to apply after a contract has been performed in full, whether an action for reimbursement of sums received under the contract terms deemed unfair may be subject to a time limit of 3 years, which starts to run from the time where the contract ended. So what happened in this case? That according to Raiffeisen Bank, as the contract was performed in full, the clients were no longer consumers. Anyway, they should have brought the action within 3 years before the contract was performed in full, so not after the full performance of the contract. But this provision concerned just consumers, because according to national law, for similar domestic legal action, this limit starts to run as from the judicial finding of the cause of those actions is established. So what the court said? First, that the obligation for a national court to exclude an unfair contract term imposing the payment of amounts that prove not to be due entails, of course, the reimbursement of that amounts. However, in the absence of rules under EU law, is for the domestic legal system of each member state to lay down the detailed procedural rules. Those rules must not, however, be less favorable than those governing similar domestic rules, similar domestic action according to the principle of equivalence, and must not render practically impossible or excessively difficult the exercise of rights conferred by EU legal order, according to the principle of effectiveness. As regards the principle of effectiveness, the court recalled that the system of protection implemented by directive on unfair terms in consumer contracts is based on the idea that the consumer is in a weak position vis-à-vis seller or supplier. In that regard, even if a 3-year time limit appears in principle sufficient, the court pointed out that in this case it was not, because the time limit set out for the similar domestic legal action was different, and so it was contrary to the protection of the rights of the consumer. I pass now to the section concerning the passenger rights. I choose the few cases I would like to talk to you about. The first case is the flight right case, judged by the court in February 2020. What happened in this case? Let's have a close look at the facts. In this case, 2 passengers booked the journey with connecting flights under a confirmed single booking. We have the journey was divided in 3 legs. We have a first leg from Germany to UK, operated by British Airways, and then 2 following legs. The second one from UK to Spain, operated by Iberia, and the third one from Spain to Spain, Madrid to Santander, San Sebastian, operated by Iberia again. What happened? That the third flight was cancelled. And so, as the third flight was cancelled, the flight right on behalf of the passengers brought an action against Iberia, but before the German courts. They claimed for compensation according to the regulation. The German court questions whether it has jurisdiction over the dispute in respect of the leg of the journey that was cancelled, given that the place of departure and the place of arrival of that leg of the journey are outside its territorial jurisdiction. So the German court notes as well that in a previous judgment of 11 of July 2019 in České Airline case C502 of 2018, the court stated that the air carrier that operated the first leg of the journey could be sued for all connecting flights in that journey. But the referring court is unsure whether the air carrier in charge of the final leg of such journey, Iberia, may also be sued before in the context of a claim of compensation on that basis. So the court says, what did the court say? The court said that compensation claims for the cancellation of the final leg of the journey may be brought before the courts of the place of departure of the first leg of the journey, even if they are brought against the air carrier in charge of the final leg of the flight of the journey. So the German court has jurisdiction for a compensation claim brought against Iberia. The claim could be brought in Germany before a German court, according to the court, as one of the principal places of provisions of the services, and the criterion of the place of departure of the first leg of the journey satisfies, according to the court, the objective of proximity between the contract for carriage by air and the competent court. The second case concerns Finnair. This is a case where a number of travelers booked a direct flight from Helsinki to Singapore with Finnair. The direct flight was cancelled and they were rerouted on a second flight. In this case, the second flight was delayed. So what did the passengers do? They asked for a compensation for both flights. Finnair paid the compensation for the first flight, but they refused to grant their second claim on the ground that they were not eligible for a second compensation payment under the regulation, because Finnair could just pay for the flight that was cancelled, not for the rerouted flight. In this context, the Court of Appeal of Helsinki asked to the court whether an air passenger who has received compensation for the cancellation of a flight is entitled to compensation for the delay of the rerouting flight. The court states that the regulation does not contain any provision intended to limit the rights of passengers who find themselves in a situation of rerouting, such as that at issue, including a possible limitation of their right of compensations. It means that the fact that the first flight was cancelled and the second flight after rerouting is delayed does not have any impact on the rights of the passengers. The passenger is a consumer concerning the first flight, and is also a consumer in the second flight that has been rerouted and then delayed. It follows that an air passenger who, having accepted the rerouting flight offered by the air carrier following the cancellation of his flight, reaches his final destination 3 hours or more after the arrival time originally scheduled, is entitled to a compensation. Why is that possible according to the court? Because the inconvenience that he had for the first flight is exactly the same that he's having for the second flight. Let's pass now to this third case. This case concerns Air Scandinavia. I'm just talking about this case because it concerns a case where a passenger signed a contract with a travel agency. The contract that he signed included a flight that was delayed. So the passengers asked for a compensation before national court, and the air carrier refused to pay the compensation because they said that there was no contract between the passenger and the air carrier. So what did the court state? That in a situation where the air carrier performed the flight on behalf of a travel agency, which entered into a contract with the passenger, the latter, when his or her flight is subject to a long delay, may rely on the regulation on the rights of air passengers against the carrier, even in the absence of a contract between the passenger and the carrier. Why? Because an action for compensation brought by the passenger against the operating air carrier must be regarded as covering matters relating to a contract. So the action can be brought before the course of the place of the departure of the flight. This case is interesting, in my opinion. This is the TAP case judged by the court in June 2020, because at first lecture of this case, it seems to be in favor of the air carriers, but it's not. It's a good example of what we can call the carrot and stick approach of the Court of Justice in this case. The dispute in this case is between a passenger and the TAP Airlines concerning its refusal to compensate the passenger whose connecting flight was subject to a long delay in arrival at its final destination. Why the air carrier refused to pay the compensation? On the ground that the delay to the flight concerned was the result of the unruly behavior of a passenger on a previous flight, which had an impact on the following flight. So, according to their company, these circumstances could be classified as extraordinary within the meaning of the regulations, which exempted it from its obligation to pay compensation under that regulation. What did the court say? That the unruly behavior of an air passenger may constitute an extraordinary circumstance capable of exempting the carrier from its obligation to pay compensation for the cancellation or long delay of the flight concerned or of a subsequent flight operated by that air carrier using the same aircraft. However, according to the court, in the event of the occurrence of that extraordinary circumstance, the air carrier which seeks to be exempted from its obligation to compensate passengers must deploy all the resources at its disposal to ensure reasonable, satisfactory, and timely rerouting, including seeking alternative direct or indirect flights, which may be operated even by other air carriers, whether or not belonging to the same airline alliance, and arriving at a scheduled time that is not as late as the next flight of the air carrier concerned. So the court considers that when in this case the consumer is subject to sacrifice which causes him a situation where he's not comfortable, the air carrier must do all its best to put the consumer in a situation of comfort. Let's have a look at the last case. This case concerned was brought against SmartWings Poland, and it is an example of how the approach of the court in this case is, I would say, consumer-friendly. What happened? A passenger bought a ticket for a flight that was delayed by more than 3 hours. Delphi, a company established in Warsaw, in Poland, brought an action against the air carrier, requesting the compensation in Polish zlotys and not in euros. SmartWings Poland refused to pay the compensation because it considers that the claim for compensation should be rejected on the ground that, inter alia, that claim had been expressed contrary to the provision of the national law in Polish zloty and not in euros. The court notes, first of all, that the main objective pursued by the air passengers regulation is to ensure a high level of protection of passengers. It follows, according to the court, that the provisions conferring rights on air passengers must be interpreted broadly. So, according to the court, if we refuse to compensate the damage to a passenger, or we put the condition that the compensation must be paid in euros and not in other national currency, we are restricting the exercise of that right, and therefore the court requires for a broad interpretation of those provisions. It means that the actions can be introduced by asking the air company to reimburse in a different currency and not only in euro. Let's switch now to the third section of cases I would like to talk to you about. This is a section in which I would like to talk with you of 2 cases. The first case is a judgment of the court delivered last Tuesday. The case concerns the processing of personal data in the electronic communication sector. The Court of Justice had to deal with the general and indiscriminate transmission of traffic data and location data. As you know, in the last years, the court has delivered a few judgments on the retention of and access to personal data in the field of electronic communication. But in particular, in a judgment in Teletius, Verige, and Watson, the court held inter alia that member states could not require providers of electronic communication services to retain traffic data and location data in a general and indiscriminate way. This judgment has caused a few issues in certain member states, which consider that they may have been deprived of an instrument which is necessary to safeguard national security. In this context, proceedings were brought in UK, France, and Belgium before national courts concerning the lawfulness of national legislations adopted by certain member states, laying down an obligation for providers of electronic communication services to forward users' traffic data and location data to public authority or to retain such data in a general and indiscriminate way. For which purpose? For the purpose of safeguarding national security in the Privacy International case brought before jurisdictions in UK, or as a preventive measure in the other member states, France and Belgium, in the connected case. So the national courts asked to the Court of Justice whether Directive on Privacy and Electronic Communications, Directive 2002/58, read in the light of Article 4, Paragraph 2 TEU and the fundamental rights granted by the Charter, is to be interpreted as precluding such national legislations. When we say that data are processed and acquired in a general and indiscriminate way, what are we talking about? As pointed out by the Court at paragraph 51 of its Privacy International judgments, national provisions cover data necessary to identify the source and destination of communication, determine the date, time, and length of the type of communication, identify the hardware used, locate the terminal equipment and the communications. The data includes also the name and address of the user, the telephone number of the person making the call and of the person receiving the call, the IP address, and all the websites that have been viewed with this laptop, telephone or GSM or laptop. In Privacy International judgment, first of all, the Court of Justice rejects the objection moved by certain member states. Just to give you an idea, 16 member states intervened in these proceedings, and they considered that the directive was not applicable to the national legislation at issue, as the purpose of that legislation is to safeguard national security, which is the sole responsibility of the member states according to the third sentence of Article 4, paragraph 2 TEU. Then the Court of Justice recalls that Directive 2002/58 is based on the obligation of principle, according to the Court, to ensure the confidentiality of electronic communications and the related data, and on the prohibition on storage of such data. This means, according to the Court, that the directive does not authorize the member states to adopt, for the purposes of national security or as a preventive measure, legislative measures intended to restrict the scope of rights and obligations provided for in that directive. In particular, the obligation to ensure the confidentiality of communications and traffic data, unless such measures comply with general principles of EU law, including the principle of proportionality and the fundamental rights granted by the Charter. By contrast, the Court holds that in situations where the member state concerned is facing a serious threat to national security that proves to be genuine and present and foreseeable, that directive, read in the light of the Charter, does not preclude the decision ordering to providers of electronic communication services to retain, generally and indiscriminately, traffic data and location data. In that context, the Court specifies that the decision imposing such an order for a period that is limited in time to what is strictly necessary must be subject to effective review by court or by an independent administrative body, whose decision is binding, in order to verify that one of those situations exists and that the conditions and safeguards laid down are observed. I will switch now to the pending Facebook Highland case. This case concerned the processing of personal data by Facebook, consisting in placing and collecting cookies when internet users visit a web page forming part of the facebook.com domain or a third-party website. This question was already analyzed by the Court in a previous case, in case C210 of 2006, Bishtaff Academy, where the Court confirmed that cookies placed by Facebook are active for 2 years and are stored by Facebook on the hard disk of the computer or on the GSM or tablet of the user, of the internet user. And this was done, the Court pointed out in its judgment in Bishtaff Academy, even if the internet user was not a Facebook user. In that occasion, the Court was faced, among others, with the question of whether, under the provisions of Directive 95/46, the German supervisory authority, which considered that the processing of personal data by Facebook was unlawful, could bring an action directly against Facebook Ireland. Why against Facebook Ireland? In its quality of collector of the personal data at issue. But there was a problem in this case, because according to a previous decision of the Data Protection Commissioner, the supervisory authority in Ireland, the same processing of data was not unlawful at all. So we have two different supervisory authorities which have different point of view on the processing of data made by Facebook, and the German one doesn't know what to do, because the Irish authority has already stated that the same processing of data is not unlawful. What did the Court of Justice say? In paragraph 69 and 70 of the judgment, the court stated that under Article 28 of Directive 95/46, the supervisory authorities have to cooperate, in particular by exchanging all useful information among them. However, that directive does not lay down any criterion of priority governing the intervention of one supervisory authority against another supervisory authority, and does not lay down an obligation for a supervisory authority of one member state to comply with the position which may have been expressed by the supervisory authority of another member state. Thus, a supervisory authority which is competent under its national law is not therefore obliged to adopt the conclusion reached by another supervisory authority in an equivalent situation. What does it mean? That under Directive 95/46, the German Data Protection Authority could exercise its own powers directly against Facebook Highland. Why I'm talking to you about this case? Because the situation has changed with the adoption of the GDPR. Because at Article 56, the GDPR establishes now the one-stop shop mechanism. According to this provision, without prejudice of Article 55, the supervisory authority of the main establishment or of the single establishment of the controller or processor of personal data shall be competent to act as lead supervisory authority for the cross-border processing of this data. But Article 55 establishes the general competence for each supervisory authority. So, in the pending case, the Facebook Highland case, what happened that the Belgian DPA, Data Protection Authority, brought legal action against Facebook for infringement of EU data protection law. In essence, the referring court asks whether the one-stop shop mechanism prevents data protection authority or countries where the controller does not have its main establishment from exerting their powers under the regulation. According to the Belgian Data Protection Authority, the one-stop shop mechanism is an exception to the general rule on territorial competence laid down in Article 55 of the GDPR. Facebook, of course, has a different view. In this case, the opinion of the Advocate General will be delivered on the 17th of December 2020. I'm in charge of this case, so I cannot give further details, but what can I just say is that the one-stop mechanism has the purpose of avoiding the fragmentation of interpretation and application of the GDPR provisions among member states by the different supervisory authorities. In a certain way, this purpose corresponds to the mission of the court in preventing different interpretation and application of EU law among member states. And therefore, it must be seen, in my opinion, as a necessary step to ensure an effective protection of consumers. However, I think that this mechanism cannot work in the absence of an effective cooperation among supervisory authorities, which has to be reached following in full the relevant provision laid down in the GDPR. So it will be interesting to see how in this judgment the court, if the court will be able to balance correctly the exigence of the GDPR to ensure the cooperation between supervisory authority, and at the same time the necessity of avoiding fragmentation of different decisions concerning the same processing of personal data adopted by different supervisory authorities in different member states. Thank you very much for your attention.